Hey y'all, it's Cam again. So this is Darren Indyke. He was actually the attorney for Jeffrey Epstein. Obviously, I'm not going to let this go. I know that's what a lot of people, even Trump with his what do you call it, Epstein hoax or Democrat hoax thing, was saying. But I'm not going to let it go. I'm just going to keep recording the videos, whether people watch it or not. We'll probably do about 45 minutes because this is 6 hours and 45 minutes. I'm not sitting here obviously for that long, but let's go ahead and let him play. You'll hear questions obviously from the minority and the majority and whatever. But I think this is the Committee on Oversight and Government Reform. Somebody put it as the government, what do they call it? The GOP Oversight Committee. But anyway, let's play it and I'll set my timer. Just give it a minute to start.
Time is 10:05 and we'll go on the record. This is a deposition of Mr. Darren Indyke conducted by the House Committee on Oversight and Government Reform under the authority granted to it pursuant to House Rule 10. Accordingly, House Rule 10 grants the committee broad jurisdiction for the committee to conduct investigations of any matter at any time. On January 7th, 2026, the committee voted to approve a motion directing the chairman to authorize and issue a subpoena to you for a deposition. On January 23rd, 2026, Chairman Comer issued a subpoena for Mr. Indyke to appear today for a deposition in furtherance of the committee's investigation into the actions and investigations of Mr. Jeffrey Epstein and Ms. Ghislaine Maxwell. I will enter the subpoena and corresponding cover letter as Exhibit 1. The committee noticed the deposition for Mr. Indyke on March 4th, 2026. I will enter the notice for this deposition as Exhibit 2. Can the witness please state his name and spell his last name for the record?
Darren Indyke, Indyke.
Thank you, Mr. Indyke. My name is Jack Emmer, and I am the Chief Counsel for Investigations for Chairman Comer. Under the Committee on Oversight and Government Reform's rules, you are allowed to have a counsel present to advise you during this deposition. Do you have a counsel representing you in a personal capacity present with you today? Will counsel please identify themselves for the record?
Mark Weinstein from Hughes, Hubbard and Reed.
Daniel Weiner, also from Hughes, Hubbard and Reed.
Thank you. Now, starting with the majority staff, can the additional staff members please introduce themselves with their name, title, and affiliation?
Billy Grant, Deputy Chief Counsel for Investigations for Chairman Comer.
Peter Spector, Deputy Director of Oversight for Chairman Comer. Daniel Ashford, General Counsel for Chairman Comer.
Ryan Gigetti, Chief Counsel for Chairman Comer.
Will Harness, Professional Staff, and Chairman Comer.
Alison Tolan, Counsel for Chairman Comer. Whitney Burnett, Senior Counsel for Chairman Comer. Emily Fadaran, Counsel for Chairman Comer. Nick Ackley, Professional Staff.
Jack Furlan, Counsel for Chairman Comer. Melvin Soto, Digital Director for Chairman Comer.
Thank you all. Mr. Indyke, before we begin, I would like to go over the ground rules for this deposition. The questioning will proceed in rounds. The majority will ask questions for an hour, and then the minority will have an opportunity to ask questions for an hour if they choose. To the extent members have questions for the witness, they will be propounded during their side's respective rounds. The clock will stop if you need to confer with counsel, your counsel is speaking, and when members or staff are speaking during the opposing side's rounds of questions. We will alternate back and forth until there are no more questions. Do you understand?
Mm-hmm.
There is a court reporter taking down everything I say and everything you say to make a written record of the deposition. For the record to be clear, please wait until the staffer questioning you finishes each question before you begin your answer, and the staffer will wait until you finish your response before proceeding to the next question. Further, to ensure the court reporter can properly record this deposition, please speak clearly, concisely, and slowly. Also, the court reporter cannot record nonverbal answers such as nodding or shaking your head, so it is important that you answer each question with an audible verbal answer. Do you understand?
I do.
Exhibits may be entered into the record. Majority exhibits will be identified numerically. minority exhibits will be identified alphabetically. Do you understand?
I do.
We want you to answer our questions in the most complete and truthful manner possible, so we will take our time. If you have any questions or do not fully understand the question, please let us know. We will attempt to clarify, add context to, or rephrase our questions. If we ask about specific conversations or events in the past and you are unable to recall the exact words or details, you should testify to the substance of those conversations or events to the best of your recollection. If you recall only a part of a conversation or event, you should give us your best recollection of those events or parts of conversations that you do recall. Do you understand?
I understand.
You are required by law to answer questions from Congress truthfully. This also applies to questions posed by congressional staff in this deposition. Do you understand?
I do.
If at any time you knowingly make false statements, you could be subject to criminal prosecution, including but not limited to perjury. Do you understand?
I do.
This includes both knowingly providing false testimony, but also stating that you do not recall or remember something when in fact you do. Do you understand?
I do.
Furthermore, you cannot tell half-truths or exclude information necessary to make statements accurate. You are required to provide all information that would make your response truthful. A deliberate failure to disclose information can constitute a false statement. Do you understand?
I do.
Is there any reason you are unable to provide truthful testimony in today's interview?
No.
Please note, if you wish to assert a privilege over any statement today, that assertion must comply with the rules of the Committee on Oversight and Government Reform. Pursuant to that, Committee Rule 16C1 states, for the chair to consider assertions of privilege over testimony or statements, witnesses or entities must clearly state the specific privilege being asserted and the reason for the assertion on or before the scheduled date of testimony or appearance. For the purposes of this deposition, objections must be stated concisely in a non-argumentative and non-suggestive manner. If the witness refuses to answer a question to preserve a privilege, the committee may seek a ruling from the chair. If the chair overrules any such objection, the witness shall be ordered to answer. If the witness continues to refuse to answer a question despite being ordered to do so, the witness may be subject to sanction. Do you understand?
I do.
Ordinarily, we take a 5-minute break at the end of each hour of questioning. But if you need a longer break or a break before that, please let us know and we will be happy to accommodate. However, to the extent there is a pending question, we would ask that you finish answering the question before we take the break. Do you understand?
I do.
Finally, I will note for everyone here today that the contents of what we discuss in the deposition today is confidential under the House Deposition Regulation. Under the rules, the chairman and ranking minority members shall consult before any release of testimony or transcripts, including portions thereof. This means it is a violation of House and committee rules to disclose the content of the deposition prior to its official release. For this reason, the marked exhibits that we will use today will remain with the court reporter so that they can go into the official transcript, and any copies of those exhibits will be kept at the table or returned to us when we finish. Can the reporter please swear in the witness?
Raise your right hand. You solemnly declare or affirm under penalty of perjury that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Do you have any questions before we begin?
I do not.
We understand that you have an opening statement that you'd like to read into the record.
I do. Thank you. Good morning, everyone. I'd like to thank the committee for working with the Epstein estate over the past 6+ months. As a co-executor of the estate, I have done my very best to cooperate with the committee and to respond to the committee's requests for documents, photographs, and other information relating to Jeffrey Epstein. As you know, the estate produced voluminous materials in response to the committee's subpoena and communicated regularly with both the committee's majority and minority staffs on the timing, scope, and content of the estate's responses. My appearance here today, as with my co-executor's testimony before the committee last week, represents our continuing cooperation with the committee's efforts to investigate matters regarding Mr. Epstein. In addition, since we were appointed in 2019 by the United States Virgin Islands Probate Court as co-executors of Mr. Epstein's estate, we have fully cooperated with the U.S. Department of Justice's investigation of Epstein-related matters. I'd also like to note the extensive efforts that my co-executor and I have made to address the wrongs committed by Mr. Epstein during his lifetime. At our direction, the estate initiated, developed, and funded the Epstein Victims Compensation Program, the first of its kind established by an estate, which provided a private, voluntary, and non-confrontational means to compensate women who suffered sexual abuse by Mr. Epstein. Independently administered by preeminent figures in the field of victims' compensation, the EVCP awarded more than $121 million to 136 women, all of which the estate funded, pursuant to our express direction that 1, there was to be no cap on monies awarded, either individually or in the aggregate, and 2, even women whose claims were time barred or who had previously signed releases could participate. The estate has also directly settled claims by an additional 59 women for a total of more than $48 million. Including the recently proposed settlement in a putative class action lawsuit filed in 2024 on behalf of all women abused by Mr. Epstein, a settlement that the court preliminary approved earlier this month, my co-executor and I have authorized payment by the Epstein estate of more than $200 million to women who assert they were abused or trafficked by Mr. Epstein. Let me be clear. I had no knowledge whatsoever of Jeffrey Epstein's wrongdoings. My complete lack of involvement in that misconduct is a matter of record. Not a single woman has ever accused me of committing sexual abuse or witnessing sexual abuse, nor claimed at any time that she or anyone else reported to me any allegation of Mr. Epstein's abuse. I did not socialize with Epstein, and I reject as categorically false any suggestion that I knowingly facilitated or assisted Mr. Epstein in his sexual abuse or trafficking of women, or that I was aware of his actions while I provided legal services to him. Far from being Mr. Epstein's lieutenant or chief of staff, as I have been incorrectly described by plaintiffs' lawyers and uninformed journalists, I was one of many attorneys who Mr. Epstein regularly consulted, including such noted luminaries as Kenneth Starr, for entirely legitimate purposes. My primary role was to provide corporate, transactional, and general legal services to Mr. Epstein and his companies, and yes, I did so. The press and plaintiffs' counsel have mischaracterized cash withdrawals I made from Mr. Epstein's bank accounts from 2013 to 2017. Entirely ignored in that reporting is the fact that the bank involved knew full well that these accounts belonged to Mr. Epstein. Neither I nor he made any effort to disguise his name or identity. And as part of its standard policy, the bank itself imposed a $7,500 limit on daily cash withdrawals. I was not attempting to structure such withdrawals to avoid federal reporting requirements. Quite the contrary, I simply sought to comply with the bank's internal requirements and limits, with the bank's full knowledge. It is undisputed that during this time, Mr. Epstein had difficulty accessing credit cards from major banks. Instead, he and his staff required cash to pay for a wide variety of expenses, including maintenance, repairs, and daily household needs for his residential properties in New York, Florida, New Mexico, Paris, and the USVI, as well as meals, gifts, gratuities, and fuel for his private aircraft. For a person in Mr. Epstein's financial position, with 5 multi-million-dollar residences, staffed by dozens of employees, and with an extensive travel itinerary, it did not strike me as unusual that Mr. Epstein's business, household, and personal needs required large amounts of cash on a regular basis. I never believed that the cash I withdrew from Mr. Epstein and his staff was used by Mr. Epstein or his staff for any improper purposes. There have also been allegations of my supposed involvement in facilitating forced or sham marriages between women in Mr. Epstein's life. Those allegations, too, are 100% untrue. I did not arrange, assist, or facilitate any marriages between acquaintances of Mr. Epstein, nor was I aware in advance that such marriages took place. Same-sex marriage has been legal in New York since 2011 with this passage of the Marriage Equality Act. It did not consider it appropriate to interrogate anyone as to the reasons for their decisions to marry or the bona fides of their relationships. I don't mean in any way to condone or excuse Mr. Epstein's reprehensible conduct. Quite the opposite, I condemn it wholeheartedly. Had I known that he was abusing or trafficking women, I would have quit working for him at once and severed all ties to him. The truth is that I did not know what Mr. Epstein did after hours, what he did behind closed doors, and what he did in places where I was not present. I first met Epstein in 1996 when he was already a highly successful businessman. After he pled guilty in 2008 to procuring a person under the age of 18 for prostitution, Mr. Epstein appeared to me to be devastated and extremely contrite. He was adamant that he had no idea that anyone involved was underage. He personally assured me that he would never again let himself be in that position. I believed him. And I made the mistake of believing that Mr. Epstein would not again commit a crime. I deeply regret doing so. Most importantly, I feel horrible for the women whom Mr. Epstein abused. While my professional association with Jeffrey Epstein has subjected my family to death threats and malicious personal attacks, I don't expect the members of the committee or of the public to feel sympathy for me. But I am left trying to explain what many people who knew Jeffrey Epstein have noted after his death. He led two entirely separate lives, his professional one and the other, a private, personal one that caused many others to suffer. That I did not know what my client did in his private life may be difficult for some to believe, but it's true. Thank you.
Starting with the majority, may all individuals, members, and staff who have since joined us since the beginning, please announce themselves for the record.
James Comer, Chairman for the deputy. Andy Biggs, Councilman, there's on the flag.
William Timmons, South House Fourth Congressional District.
David Mann, James Watson.
Thank you. The time reads 10:22 and the majority's time will begin now. Mr. Indyke, let's begin by discussing your education and experience. Where did you attend undergraduate school?
Colgate University.
And what degree did you graduate with?
A degree in education and economics.
What year did you graduate?
1986.
And where did you attend law school?
Cornell Law School.
And when did you graduate law school?
1991.
When were you admitted to practice law?
1992.
In what states were you admitted?
New York, initially.
And where have you since been admitted?
In 2019, I was admitted to practice law in the state of Florida.
Is your license currently in good standing?
I believe my licenses in both New York and Florida are in good standing.
Can you briefly go through your professional career up until now?
Sure. When I graduated Cornell Law School, I worked as first a clerk and then as an associate for the law firm of Golden Wachtel. I did that until I think it was 1994. In 1995, I joined the law firm of Greenberg Trard in New York City. I worked there until sometime in 1996, towards the beginning of 1996, at which point I was asked by someone who was a former partner at Golden Wachtel to go work for him and with him to represent Jeffrey Epstein and his company. And since then, I have been working to represent primarily Jeffrey Epstein, both as an employee and then subsequently as in my capacity as a law firm, my own law firm.
Prior to your employment with Mr. Epstein, what areas of law did you practice?
Corporate securities and trademark law.
When did you first meet Jeffrey Epstein?
Sometime in 1996, towards the beginning of 1996.
And Mr. Indyke, I understand that you're hard of her hearing, so we're gonna try to speak up, but if you could also speak up as well for everyone in the room.
Sure.
So let's begin again. When did you first meet Jeffrey Epstein?
It was, I believe, towards the beginning of 1996,
Where did you meet him?
at his office in New York City.
And why did you meet him at that time?
Prior to my meeting Mr. Epstein, the partner that I worked for at Golden Martel has asked me to come work with him to represent Mr. Epstein. And as part of me doing that, he wanted me to meet Mr. Epstein in his office. So I did so.
And for the record, I missed this. Who else was present during this meeting?
I don't recall, it was many years ago. That partner may have been there. So it would have been him and Mr. Epstein. I think. I don't recall anybody else.
And what did you discuss with Mr. Epstein at this time?
I can't recall specifically, but basically he asked me questions about my background, corporate and securities background, about the work I did at Golden Martel and the work I did at Greenberg Traurig. Told me I'd be doing similar work for him.
Prior to meeting Mr. Epstein, what did you know about him?
Very little. When I worked at Golden Martel, I understood that he was a client of Golden Martel. And I understood that the partner that I worked for at Golden Martel had done some work with him along with one of the main partners, Bob Gold. But that's the extent of what I knew about him.
And what you testified to was all related to his business. Did he have any reputation outside of his business as it related to young women or girls at this time?
Not that I knew of.
What were your first impressions of Mr. Epstein?
I was slightly intimidated because he was explained to me to be a very wealthy man. I was not very wealthy, and I was very young at the time. And he was explained to me to be a very successful businessman. My impression for him was that he was no nonsense. He seemed pleasant enough. Nothing more than that.
What did you understand his job to be at this time?
I understood that I would be providing support and assistance to the partner that brought me in connection with representing Mr. Epstein's business interests.
And you mentioned that
I think, Jack, did you ask what did you understand his job to be or your job to be?
Mr. Epstein's job.
Yeah.
Oh, I'm sorry. Forgive me. Mr. Epstein's job, my understanding was that he was a financial consultant for a wealthy individual.
Did you know who his clients were at this time?
No.
Just because you mean before he took the job?
Correct. We've had a member join.
Ugh.
Mr. Indyke, recognizing that we'll discuss more specifics later, can you briefly describe the nature
And she'll, the first thing out of her mouth is, "What did you know about Jeffrey Epstein and Donald Trump?" That's going to be like one of her first lines of questioning. Anyway, I can't stand her. I thought she was leaving the Senate or what, or leaving the House of Representatives. I know she's running for Senate, but she cannot. No, we need her out of here.
sense of your relationship with Mr. Epstein?
I was one of Mr. Epstein's many attorneys. My role was primarily a role as a corporate and transactional attorney. My role was to review documents, summarize documents, analyze documents, critique documents, draft documents in a wide variety of areas. Investment documents, private placement memorandums, subscription agreements, option agreements, warrant agreements. Let's see what else. Registration rights agreements, stock purchase agreements, rights of first refusal agreements, all of those in kind of side letters for investments, all of those in the investment field. There were times when he would do some trading, and my role was to review the trading confirmations. And to the extent there were documents required as a precursor to the trading, like interest swap agreements, things like that, I would review the interest swap agreements. To the extent that I had any comments on those, I would give my comments on those agreements. If Epstein was going to buy or sell a business, there were times when I would be required to draft basic business agreements or letters of intent, or review a purchase agreement or a sale agreement, and critique it and summarize it and provide any evaluation on it. Epstein had aircraft, and his clients had aircraft. I was involved as an attorney in connection with the acquisition and sale of aircraft, fixed-wing aircraft, helicopters, rotorcraft, both new builds from manufacturers like Sikorsky, and sometimes when there were resales of the aircraft. Also, there was lots of real estate that was being acquired and sold during this time. So I would work with local counsel. If it wasn't in New York, for example, I would work with, and sometimes even if it was, I would work with local real estate counsel in the acquisition or sale of real estate, anything from large acreage ranches to islands to townhouses to apartments to homes, any number of parcels of real estate. In connection with some of the real estate that was acquired, there was a lot of construction going on during the course of my representation. And that construction would require architects and design. So I would review AIA architectural and design agreements, again, summarize, critique, evaluate. I would review proposals, just to make sure that the proposals for any particular building or design were incorporated all of what I understood to be the kind of the roles or the program for the building that was to be done. There was construction management agreements that had to be reviewed, general contractor agreements that had to be reviewed. Sometimes liens would come up. So all of that, those things would have to be reviewed. From time to time, when a new asset like an aircraft or a helicopter or even a large boat would be acquired, a new entity would be formed for that asset, because that asset was a large, tended to be as an aircraft. Aircraft could fall out of the sky. They could cause serious damage. So kind of it's corporate law 101, and make sure that when you have a kind of a liability type asset, you put that asset in a separate entity. So other assets held by the person can't be subject to the liability that is created by that asset. The same holds true for, it's kind of normal operating procedure, particularly for people in high net worth situations. When you would take on a new investment, or there would be an investment program, you would form a separate entity for that investment program. For new businesses, because you didn't want to mix a new business with an old business, you would form an entity for that new business. So part of what I did is, either if it was some place that in the jurisdiction where I was admitted and I knew of a corporate service company to do it, I would have a corporate service company form the entity. If not, I would have a local attorney do the same. So we did those things. Just kind of the type of things sometimes are very, very complex. There was just to give you an example, there was a project that required connecting one of Epstein's islands, because he had two, that island to the St. Thomas mainland, and that required the manufacture of a 15 kV cable with fiber optic capabilities by this Italian manufacturer. So I would have to work on that agreement with the manufacturer, and then we'd have to do, I'd have to work on a separate agreement for the installation of that cable across the span from St. Thomas mainland to the island, and then you'd have to work on the local to step down the cable. All the work that the electrical contractors had to do to connect the cable to the island. And then there was also permitting that I had to work with local council who handled the permitting, and local environmental consultants to do the permitting to lay the cable on the ocean. So lots of different things like that. It was, yes.
I just have a couple questions related to the number of attorneys. You mentioned there were a number of attorneys working in-house essentially for Mr. Epstein. Is that correct?
No, it was a number of attorneys that Mr. Epstein engaged.
Okay, so how many were actually working in-house?
At which time, sir?
Give me an example. Early on.
Early on, 3 attorneys.
And then as the time went on?
2 attorneys. And then ultimately, nobody was working in-house. Ultimately, he was using outside counsel, including me as outside counsel, and other attorneys as outside counsel.
You had 3 attorneys. Are you one of those 3?
I was one of the 3 attorneys.
You got down to 2, obviously you were one of them.
Was still, yes, one of the attorneys.
And you continued on until?
I continued on with the other attorney. I was there, but the other attorney formed an entity to serve Epstein and other clients, and I worked for that entity, and I was a key member of that entity. And then ultimately, I formed my own law firm.
Did you have any associates in that law firm partners?
No.
Sole proprietor?
I was.
Thank you.
Sure.
We've had more members and staff join. Can they please announce themselves for the record?
Robert Garcia, I'm the ranking member for Oversight Democrats. Road Honda, California, 17.
I want to stick with asking general questions to start. So during the course of your representing Mr. Epstein, how often did you communicate with him?
Towards the beginning, infrequently. I saw him from time to time. I spoke to him from time to time, but mostly his communications were with the partner that I worked with. And then the partner that I worked with would speak to me about assignments that I had specifically. Over time, I would have some interactions with him. I would get direct assignments from Mr. Epstein.
And you mentioned the partner, that's the same partner you referenced before.
Yeah, it's the partner who kind of asked me to come and join him representing Mr. Epstein.
For the record, what was his name?
His name was Jeffrey Shantz.
And how would you typically communicate with Epstein?
At which time?
During the course of your relationship.
Okay, so multifaceted. Sometimes I would get messages. Sometimes I would get a communication through the partner. Sometimes he would be in the office, and I would meet with him for 2 minutes. Not a lot of FaceTime. And get a specific assignment. And then sometimes I would get a message from his assistant saying something that Epstein wanted from me. And towards the later end, I would meet with him when he no longer had an office in New York. Towards the later end, I would meet with him. I would meet with him on the ground floor in the dining room of his residence.
How often would you meet with him at the residence?
It really depends when. So towards the beginning, not at all. As time went on, once a month, sometimes twice a month. If he was in town and there was a transaction going on, could have been more, but typically it was about twice a month.
How long would your meetings last when you would visit his residence?
Typically an hour or so, maybe two, most.
Who typically would be present?
That's there is no kind of typical thing about who would be present. It really depended on the transaction and the specific matter that was, or matters that I was meeting with him about.
And I can hear you just fine, but there's a lot of people in the room that are struggling to hear you.
So I'm sorry.
However much you can speak up.
Okay.
Very helpful.
Yes.
But I just want to focus on who was present. There are women that have been identified and deemed as assistants of Mr. Epstein. Do you recall them being present at these meetings?
I recall women coming into the meeting, delivering a message to him, sometimes bringing some food to him, but generally his personal assistants were not in the meetings.
And you mentioned that early on you have meetings at your office, and then it seemed that it became more common that you'd meet at the residence. When did this shift occur?
I think it was 1998 when Mr. Epstein moved his residence, his primary residence, to the U.S. Virgin Islands, and his business to the U.S. Virgin Islands. So he no longer maintained an office in New York. And so when it came to New York, the requirement was to meet at his residence.
I'm going to ask you a general question here. What were the nature of your communications with Mr. Epstein?
Can you rephrase the question?
What were the nature of your communications with Mr. Epstein?
I'm trying to understand. That's very general. I don't really know.
Were the nature of your communications always related to the furnishing of legal services?
Yes.
So, for the record, did you ever have any communications with Mr. Epstein related to young women or girls?
No, absolutely not.
How would you characterize your relationship with Mr. Epstein?
It was strictly a business relationship, strictly a legal relationship.
For the record, at any point, did you consider Mr. Epstein to be a friend?
No.
Did you ever spend time with Mr. Epstein apart from your duties as his attorney?
I never socialized with Mr. Epstein. I never spent any time with Mr. Epstein other than when I was there for a status report or a legal project for Mr. Epstein.
Did you ever consider Epstein to be a mentor?
I did initially. I want to tell you a little story about that. When I first started working for Epstein, I got this assignment. I can't remember the transaction that I was working on, but I got this agreement, and he told me I needed to get it reviewed and critiqued, and I mark it up is the word they use. Mark it up and give me your comments to it. I think I had 24 hours to do it. So I went back to my office, spent a very long time in my office, probably till like 11 o'clock, 12 o'clock that night, marking the thing up. And when I gave it to him, it was full of red, completely red. And I thought I'd done a fabulous job in marking up an agreement and showing all the ways the agreement was defective. And he looked at it, kind of looked at it and said, well, what am I supposed to do with this? So I have a transaction that I have to get done within the next week. This is never going to, first of all, I don't know what's real, what's not real here, what's important, what's not important here. I can never get a transaction done if this is what I have to do. So now take this back and go find me the 10 most important things and rank them in order of importance. And I learned a huge lesson from that. And he taught me about being a practical lawyer, not just a lawyer that's finding every possible theoretical kind of loophole in the agreement. So in that respect, I thought he was very helpful. And so that's, and he had other kind of advice to me like that. Those types of things in being a lawyer to, don't guess at things that I don't know, tell them what I don't know, tell them what I do know. And if I don't know, tell them I don't know. Those are the types of things that he taught me to do as a lawyer, which were helpful to other people that I was working with as a lawyer.
Mr. Indyke, that's helpful advice. You don't be just technically proficient to help facilitate the deal. But when you were working with him, you never sat down and had friends, never sat down and smoked a cigar with him.
No, never. Two things. He doesn't drink, doesn't smoke, but that wasn't our relationship.
You didn't ever say, come along to have a cocktail party after work, come on, nothing like that.
I was never invited to a single dinner party that ever had invited to.
Thank you.
Did you ever ask Mr. Epstein for personal favors?
Let's see how to answer that question. I asked him for help when I was, I think it was my first year or so. Sorry, my first year or so when I worked for him. I don't remember the exact time period. My wife and I were having fertility issues. Infertility treatments were quite expensive. They weren't covered by insurance.
By the way, I think Richard Kahn, the accountant, also said the same thing, that they were having infertility issues or fertility issues, whatever. And I think they kind of posed something to Epstein, not for his male stuff, but maybe for money or a loan or something. I remember something about that.
So I had asked him if it was possible for me to forego the insurance, and in lieu of the amount of money that he was paying for insurance at the time, if I could take that money and apply it towards the cost of infertility treatments.
I think that's what Richard Kahn said
and
too.
at that time, his response to me was, absolutely not. You should keep your medical insurance and I will pay for your infertility treatment. Subsequent to that, it didn't work. And it didn't work, I think, 4 other times. Subsequent to that, without me having to ask, he would tell me, when are we doing the next one? And so that's being paid for all of our infertility treatments until we were able to conceive.
That's
This time I'd like to introduce what will be marked as Majority Exhibit 3. And this is a letter sent in 2008 by Mr. Epstein's criminal defense lawyers to prosecutors in Florida when Epstein was under investigations for crimes committed against minors. This is a compilation of statements from various employees of Mr. Epstein, all attesting to his good character. This document is based on the EFTA 2857458. And I would like to direct your attention to page 13. We're specifically looking at the bottom, and page 14, and I will give you a moment to review. So, page 13. Thank you. And for the record, we're reviewing the italicized portion. Did you write this, Mr. Indyke?
I believe I do.
And why did you contribute a statement for this? For this filing?
I'm trying to see what this is for. I believe I was asked by defense counsel to contribute a statement for him.
So there's a part where you mentioned that Mr. Epstein had provided emotional and financial support. Is that in reference to what you previously described as help for infertility issues?
Yes.
And for the record, again, why did Jeffrey Epstein offer to pay for these services?
I can't tell you what was in his own mind. I can tell you my perception was that he was being generous to me. He didn't really know me very long, and there was no kind of obvious benefit to him at that stage in my career with him. So I guess he was being generous. I will say this, that in the years that followed, he did this kind of thing for other employees, friends, acquaintances. He appeared to be generous. He appeared to understand that his money could do good things, and he appeared to use his money to do things like that for people.
Did he provide you any other support besides the infertility support?
Can you be more specific in terms of the time frame?
Well, we're looking at this character reference around this time, 2008.
No, that was a big deal, obviously. It was a very difficult time for my wife and I, and it was very meaningful to me to have that support.
We've had another member of Congress join. Can she please identify herself for the record?
Mr. Indyke,
Yes.
it's a poignant letter that you both here. Did you see in the whole packet that was submitted as the stuff being reported?
I don't recall.
Were you aware what the charges were pending time that you wrote your statement?
I'm trying to remember when this statement was written. It was kind of fluid at that time.
You knew that there was some kind of criminal allegation against him, which is why the criminal defense attorney was asking you to write for that. Right?
Yes, there were criminal allegations again.
No allegations.
Again, it depends at what time we're talking about. My understanding.
You speak up for the mic, so yeah.
Sorry.
I'm trying to shoot back at.
No, my apologies. I'm sorry, I'm not speaking loud enough. My understanding basically that the allegations against him at the time I think at the time that this was going on, forgive me, it's a while ago. But I think the allegations at that time, this is the state investigation in Palm Beach, were that there were massages at his house. Some of those massages wound up sexual in nature, and that at times it wound up being the case that there were some underage women there in the massage.
So you understood that those were the allegations or the number of the charges at the time you wrote your letter.
I did understand that those were the allegations, but if I could talk a little bit more about that, I'd like to, if that's okay.
And I'm sure they're going to get into that. I just want to ask one of the questions. You wrote the letter, criminal defense attorney asked you to write the letter. Did you ever discuss the charges with Mr. Epstein before you wrote your statement?
No,
You never talked to him once about these allegations before, even though you just described somewhat of what you knew about him. You did not discuss that with him at all before you wrote the good character reference.
to the extent that there were discussions with Epstein, they were always in the presence of defense counsel. There were many lawyers there, and I was a member of that group. So I never had a personal conversation with him like that, like the one that you're suggesting.
And during those conversations, I assume that Mr. Epstein wasn't he was speaking perhaps about charging.
So, well, a couple of things. I want to talk to you about them, but I will say this. I have a balance of privilege here, but I also don't want it to be that I'm trying to withhold anything from you. So at the time that this was going on, what I was learning from the defense people who were investigating was that the investigation was full of allegations that were in many ways untrue, contradicted by recorded, transcribed statements from the witnesses. What I understood from the attorneys was that the police investigation was flawed and somehow either biased, or there was something, or the facts of that investigation as described in the police report were inconsistent with recorded statements from the witnesses, omitted information that the witnesses gave them in recorded statements. There was even, if I recall, there was even in the police report reference to a trash pull where the police report indicated that they found a sex toy in the trash pull. And it later turned out that what was identified as a sex toy was in fact a broken salad utensil. And so, but when the police used the information from the report in their affidavits and their arrest warrants, they kept the part about it being on sex toys in the garbage bowl, but never mentioned the fact that it was later found to be a salad utensil. There's also no mentions in that police report about the fact that Epstein had been adamant that he didn't know that anybody was underage. In fact, there was, as I understood it, because I didn't do it, but as I understood it, there was a lie detector test, a polygraph test, which indicated that Epstein was being truthful when he said he didn't know about the AIDS.
So Mr. Indyke,
So
let's go back to an earlier question that I asked you about when in context of that charge, when in context to his adjudication of guilt and his sentencing. I assume, and you can correct me if I'm wrong, if you wrote this in connection with the sentencing or the pre-sentencing report on behalf of the defense. Is that accurate?
I don't know for a fact, but that's not what I recollect.
Okay.
I think this was done previously.
So what I find intriguing about what Richard just testified to, that mentioned the other lengthy detail about the theory of the defense of Mr. Epstein. Is you having trouble contextualizing when you wrote this particular document. I find that intriguing and a little bit difficult for me to understand why.
May I just say that the he didn't write the document, he wrote that excerpt,
Yes.
just to be clear.
No, that's correct.
Well, over the course of, the reason I can provide as much detail about the defense position is because that detail has been argued over and over and over again by the defense counsel. So it's something that has stuck in my mind. When this was written, it was written once. It is also a very long time ago. And so I can't tell you precisely when it was written. And I can't tell you, I just can't tell you the full context when this was submitted.
In your opening, you said that after 2008, after his guilty plea, you thought that he was contrite and that he learned from his mistake. And you said that you were horrified to learn of the crimes he committed after. What crimes are you referencing after 2008?
So now with hindsight,
Was he ever charged, or I'm not aware of any charge or referencing times post 2008? Is there, what charges are you referencing? What crimes are you referencing?
I'm not referencing any charges after 2008. After he was,
What conduct after 2008 is criminal? Because you said that you were horrified to learn it's criminal activity in your.
I'm not sure. I don't think I said I was horrified to learn it was criminalized. I was horrified that he hurt people, but all of that is in the context of statements that have emerged since his death.
What criminal activity?
Since his,
I'm unaware what criminal activity occurred post 2008.
I don't specifically know what criminal activity occurred post 2008. I wasn't there. I didn't see any criminal activity, but what I've seen now are allegations by a number of women that have come to light after he died, where they said all of these things happened. And while I've never seen him do anything that way, nobody's ever reported anything to me that way. Clearly, with all of these women saying this happened after the fact, I cannot say that he didn't do a lot of bad things. And so learning this after his death, I feel horribly. And that's what I said. I do feel horrible.
So, Mr. Indyke, just go back to the statement you wrote that was asserted in the defense.
Okay.
That statement. I just wondering if was it your normal practice to write such a letter of recommendation on behalf of someone without full understanding of the ramifications of what you were saying and the allegations and the context in which you were being asked to write that? I mean, did you know why you were being asked to write that specific statement?
I knew that people were saying, were making allegations against him, which were contrary to what I had observed in him. And the truth is that I felt they asked me for what he had done that was generous to me. And I felt like I could be honest about that. And so that's why I did.
So I'm aware that you were transactional and trying to tell me the general ramifications, but you understood, I would guess, as an attorney, somewhere, if I had to understand something about criminal law, that your statement was going to be used to facilitate a reduction in sentence, reduction in charges, or some benefit to Mr. Epstein in light of the rather substantial charges which you described in some detail that you were aware of.
At the time that, first of all, this is the first time anything like that ever happened. So to some extent, it's all very new to me. I am still representing the person. The person that I represented never exhibited this kind of conduct to me, was very generous to me. And at the time,
Even though he was generous to you, you understood this was going to be used to facilitate either reduction in sentence or reduction in charges.
But I also understood that the answer is, I understood that it was going, I didn't know it was going to be used for reduction of charges or reduction of benefits. I understood it was going to be used to give the law enforcement as a character reference for him. Okay, I did understand that.
And so why would you give a character reference if not for reduction of sentence or reduction in charges? I mean, that's why you give something like that to police.
That's not what was going on. That's not what I was thinking at the time. It wasn't.
All right, I'm gonna stop it here. That's about 58 minutes. I went a little bit over. But anyway, I will talk to y'all later. Y'all have a good day. I'll see y'all next time. Bye.